So what would Jesus do? Well, he sure as hell would not be canceling other people's trademarks. I'm Andrei Mincov, the founder of Trademark Factory, and in this video I'm going to share my thoughts about yet another trademarking screw-up. This time around, it's Tyler Perry successfully canceling somebody else's "What Would Jesus Do" trademark. Alright, let me start by reading from the article, as always, and you can find the link in the description below. Tyler Perry wins "What Would Jesus Do" trademark battle. His opponent at the trademark office was a reality TV star who registered first and claimed she had introduced him to the title of a proposed show. She still lost. While not scripture of ecclesiastic precept, the United States Patent and Trademark Office has declared Tyler Perry to be the winner in a battle over "What Would Jesus Do" trademark. The other contestant in this bout was Kimberly Kearney, who was once known as Popra of the VH1 series I Want to Work for Diddy. In May 2008, Perry registered the mark in the category of entertainment services, mentioning in his filing live concerts, a TV program, and motion pictures. He included a disclaimer that he wasn't attempting ownership on the exclusive right to use Jesus apart from "What Would Jesus Do." Now that didn't sound right. He wouldn't use Jesus apart from "What Would Jesus Do." Well, actually, let me comment first about this disclaimer thing. Sometimes when you have a common word or a word that's otherwise generic or descriptive, something that you are not supposed to claim monopoly over, you would be required to enter what's called a disclaimer that says to the world, well, I own the whole thing. I want to own the brand as a whole. So in this case, "What Would Jesus Do?" But I'm not saying with my trademark application that nobody else can use the word Jesus by itself, right? So that's exactly what happened in this case. So let's keep going. However, months earlier, Kearney had already filed for that same mark for a reality television program. When her "What Would Jesus Do" mark was then published for opposition 2 years later, Tyler Perry Studios stepped forward to cancel it. Although Kearney had included in her registration a printout of a web page calling for auditions on her show, Perry's reps said that she wasn't really using the mark. Perry demanded that the trademark office declare her registration abandoned, as it was blocking his own attempts to turf out "What Would Jesus Do." In subsequent papers at the Trademark Trial and Appeal Board, and by the way, we're going to go through that in a moment, Kearney attempted to make the case that she first used the mark in November of 2007, and during the initial stage of production, she shared her television program and title with Tyler Perry Studios, and that not many months after sharing this program and soliciting Perry for financial support of this program, Perry filed to register this mark, consequently eventually resulting in this cancellation proceeding. Now, again, we're going to go through the details of the paperwork, and I know by your comments that sometimes that a lot of you love me to go through those little details. So we're going to do that in a moment. But again, another comment here is you came up with an idea. Great. It doesn't mean you own the brand. You have to start using the brand and using it extensively enough for there to be use. And what's even more important is that you came up with the idea, you shared that idea with somebody else. It's very difficult to enforce that against the person that you've shared this idea to, unless you made it so clear, abundantly clear to that person that they're not to use your idea unless certain conditions are met. Usually that's done by having them sign a non-disclosure agreement, right? You could say, I am doing this amazing program. I came up with this concept. I can't tell you more until you sign. Would you like to know more? And if they sign, then this situation would not have happened because he would be under an NDA and his attempts to trademark the brand in the future would have failed. But that didn't happen. Let's keep reading. But that's hardly mattered thanks to some trademark jujitsu on the part of Perry's attorneys. They requested the admission of certain facts by Kearney that she admit she hadn't produced a television show in connection with What Would Jesus Do, that she hadn't sold one, and that she didn't intend to do so, nor had taken any meetings for such a show. Now this is key because she really did not admit that publicly. She never said, I admit. You'll see exactly what happened and you'll see exactly why stuff like this is serious. Because Kearney did not timely answer Perry's request. So they're actually quoting from the decision I'm going to go through with you in a moment. So because Kearney did not timely answer Perry's request for admission, the facts included are deemed admitted and are conclusively established, wrote administrative judges in an opinion canceling Kearney's trademark that was handed down last month and has just been promulgated. Despite respondents' denials in her answer to Perry's petition, the deemed admissions supersede those denials and we are bound by them. The judges also note Kearney's claims that Perry stole her What Would Jesus Do idea, but says that even if it was enough to support use or be a defense of unclean hands, these allegations are unsupported and we may not adduce any facts from them. If Tyler Perry does something with What Would Jesus Do, and as illustrated here, he's under some onus to actually use it in commerce, lest he also abandon the mark. This is the backstory behind it. A fascinating story, and really just shows how important it is to use your mark so that it doesn't get canceled by somebody who wants to get the same name after you. But it also shows you how important it is to take cancellation and opposition proceedings seriously. Because if you don't know what you're doing, even if you have a perfectly winnable case, the other side can easily nail you on the process. And I mean, as sympathetic as I am to Kearney, who came up with the name first, I have no reason to doubt that, especially since she filed the application first, and she could have won. The reason she didn't is because she didn't get attorneys who would do whatever it takes to properly respond to the cancellation petition by Tyler Perry. So let's go through the decision of the appeal board, and I'm going to make some comments as I read it. All right, so let's read this. So Tyler Perry Studios seeks to cancel Kimberly Kearney's registration for the mark What Would Jesus Do? In standard characters for entertainment services in the nature of an ongoing reality-based television program in International Class 41. As grounds for cancellation, petitioner alleges that respondent has never used or has discontinued use of the mark What Would Jesus Do, with no intent to resume said use, thus abandoning the mark. Petitioner further alleges that it will be damaged because respondent's registration is blocking petitioner's application. Thus, petitioner pleaded the claims of non-use or, in the alternative, abandonment. So it's two different things that mean pretty much the same thing. You're either not using it or you've abandoned your mark. And you've abandoned your mark because you're not using it and just don't intend to resume such use. So let's keep reading. In her answer, respondent admits that the trademark attorney refused their mark because her application probably preceded theirs, and their similarity to her mark in name and use, and the fact hers was already in process, okay, and otherwise denies the salient allegations. So record. By operation of the trademark rules, pleadings herein, and the file of the subject registration are of record. Petitioner submitted under Okay. Respondent did not submit any testimony or other evidence. Now that's huge, right? You want to save a little bit by saying, well, it's not fair. It's not fair. I came up with a name first. Well, you gotta look at the situation. You gotta figure it out. It wouldn't be fair. It's not enough. It's not enough. In USPTO, in Canadian Intellectual Property Office, you gotta submit evidence. The tribunal is not going to just guess. That's not how rules of evidence work in North America. Now, let's keep going. Now, as noted above, responded by her answer, admits that petitioner's application for a similar mark has been refused registration in view of respondent's registration. In addition, as discussed infra, respondent admits that petitioner is a competitor and that they offer services through some of the same trade channels. And in view thereof, petitioner's standing is established. Now, here's why this matters. In US, you can't just file cancellation request against the mark that you know is not in use unless you can show that you have some interest in killing that other trademark. You're planning to go in the same business with a similar brand. You've got a pending application that's being refused. So you have to show connection why you're interested, because they don't want trolls to just file those cancellation petitions left and right and bully brand owners into settling with them. So in US, you gotta show connection as to why you're interested, which is actually very different from how Canada works, because in Canada, you don't need to show that. And the strategy in Canada usually is just for a law firm to file, or a trademark agent to file such requests, so that the name of the actual client is never shown. Sometimes they can guess, but often they can't. And so in Canada, you don't have to show that connection. In US, you do. Let's keep going. Non-use. So under Section 1A of the Trademark Act, mark may not be registered unless it is used in commerce. The term use in commerce means the bona fide or good faith use of a mark in the ordinary course of trade on services, when it is used or displayed in the sale or advertising of services, and the services are rendered in commerce, or the services are rendered in more than one state, or in the United States and a foreign country, and the person rendering the services is engaged in commerce in connection with the services. So they're basically just explaining what the use is, right? Again, coming up with a name is not use. You have to start offering services to the world. And when I say the world, it means to the public, right? It can't be just your cat that's consuming your service. All right, let's keep going. Where it is found that there has been no use of the mark in commerce in connection with any of the applied for services prior to the filing of an application under Section 1A of the Trademark Act, the application is void ab initio. Now that is crucial, because in the US, if you can prove that you claimed that there was use, but there wasn't any, then the application is void from the start. It's not that you are canceling it. It's that it's as if the application never existed. Okay, let's keep going. So in this case, the operative date is January 14, 2008, the filing date of the application which issued into the subject registration. So all Tyler Perry had to prove is that there was no use on or before January 14, 2008. Petitioner argues that respondent has not used the mark in connection with the identified services as of the claimed date of first use, the filing date of the subject registration, and currently. Petitioner relies on its requests for admission, which are deemed admitted to satisfy its burden of proof. So the most pertinent are set forth below. So I'm going to read through them in a moment, but what it means is that in the petition, Tyler Perry said, here's what the other side, here's what Kimberly did, right? They made those allegations, and she was supposed to respond to those allegations, but she didn't. So here are the allegations. So admit that respondent and petitioner offer competing products and are competitors. Admit that respondent has not produced a television program in connection with the What Would Jesus Do mark. Admit that respondent has not sold a television program in connection with What Would Jesus Do mark. Admit that respondent has not distributed a television program in connection with What Would Jesus Do mark. Admit that respondent has not had exhibited by a television broadcast or cable network a television program in connection with What Would Jesus Do mark. Admit that respondent has no rights in the What Would Jesus Do mark based on use in commerce. Admit that respondent has not produced a television program in connection with What Would Jesus Do. They use all sorts of wording to say pretty much the same thing. But this is how it works. So if you think this is ridiculous, and actually I might agree with you, but the problem is, if you think that this is ridiculous and you don't respond to stuff like this when it's raised against you, guess what? You're going to lose, because this is how legal system operates. This is what rules of evidence are. So you may get a document with all sorts of verbiage that you think means the same thing, and you think they're liars, they're bad people, it's unfair. That's not good enough. You have to respond to each of those allegations. Otherwise, what's going to happen is what happened in this case. She didn't respond to those allegations, and boom, they're considered admitted. So let's keep going. Admit that respondent did not intend to produce a television program in connection with the What Would Jesus Do mark in January 2008. Admit that respondent's contact email addresses on the whatwouldjesusdo.tv website are non-functional and resolved to info@coolexample.com. Admit that respondent's contact email addresses on the whatwouldjesusdo.tv website have never been functional. Admit that respondent's whatwouldjesusdo.tv webpage that was used as a specimen of use in the instant application was created for the sole purpose of securing the instant registration. So they're saying the website, yeah, there was a website that you showed on the specimen, but it wasn't really a website to offer the TV show. You just did it to lie to the USPTO to say that you have use. And actually be careful with that. That's a good lesson in that as well. That, if you want to save $100 to not pay the additional $100 to convert your intent to use application towards the use application, and you just slap some stupid website and say, hey, there, that's my website. That might not be considered use. And I mean, look, you don't have to have a perfect website. That's not what I'm saying. What I'm saying is that if your intention is to launch the website and make it better and actually offer services from it, that's okay. You don't need a lot to show use in terms of services specifically. You just show a website and show some minimal use. But that minimal use has to have the purpose of offering your products and services for sale, rather than proving to the Trademarks Office that you got use and nothing else. So let's keep going. Admit that respondent had not begun to produce a television program in connection with the What Would Jesus Do mark at the time of filing the instant application. Admit that respondent does not own, administer, or have access to an email account at the info@coolexample.com address. Admit that respondent has taken no meetings in connection with the production of a television program in connection with the What Would Jesus Do mark. Admit that petitioner sells petitioner services and respondent sells respondent services through at least some of the same trade channels. So all of that. And because respondent did not timely answer petitioner's request for admission, the facts included are deemed admitted and are conclusively established. Now that is the nail in the coffin for Kimberly. because again, by not responding to that request for admission, you are deemed to have admitted all of those allegations. So if Tyler Perry had the allegation there that you admit that you shot Kennedy, you admit that, whatever else you did, and you don't respond to that, you are deemed to have admitted that. So despite respondents' denials in her answer to the petition, the deemed admissions supersede those denials and we are bound by them. Now that is huge. So in her response to the petition, she said, no, I've been using it. Seriously, look, I'm good. I've been used this, like this is all true. But because she hadn't responded to the request for admission, that fact supersedes what she wrote in the petition. Because that's not evidence. It's argument. Response to the petition is not evidence, it's argument. And evidence trumps argument every day of the week. Okay. Thus, it is conclusively established that respondent did not use the phrase, "What would Jesus do?" for entertainment services in the nature of an ongoing reality-based television program as of the filing date of her application. Now, respondent asserts in her brief that she first used the mark in November 2007, at which time she initiated the beginning stages of her reality-based television program. During the initial stage of production, respondent shared her television program and title with Tyler Perry Studios, and subsequently, respondent filed for an application to register the mark. Not many months after sharing the program and soliciting the petitioner for financial support of this program, petitioner filed to register this mark. Okay, so as noted above, respondent did not submit any testimony or evidence during trial. Therefore, even if such activities could constitute use sufficient to support a use-based application, or her pleading could be viewed as including a defense of unclean hands, these allegations are unsupported and we may not adduce any facts from them. So, a couple of things here. The unclean hands. So if you can prove that the other side is a jerk, if they're an asshole, and what they do may be correct from the legal perspective, but how they did it is bad, is wrong, sometimes USPTO or courts would deny that person any protection and actually protect you. That's called the unclean hands doctrine. You're not supposed to come to court with unclean hands, right? As what USPTO says here is that could have been good argument to make that Tyler Perry did not have clean hands, and you could have claimed that you actually had prior use because you were planning to start something, but all you did is you just made a bare assertion of that in your argument. You did not provide any evidence, and we need evidence to make decisions. We don't make decisions just by bare arguments. We need to look at the evidence. You provided none. Too bad, so sad. Respondent also appears to rely on the use statements and specimens in the file history of her registration. However, the allegation in an application for registration or in registration of a date of use is not evidence on behalf of the applicant or registrant. A date of use of a mark must be established by competent evidence. Now, again, it all boils down to evidence. She says, well, when I filed my application, I said, I've been using this mark since whatever date, and here's how it looked like. And what they are saying, cool, that's not evidence. We can't use that as evidence. Specimens in the file of an application for registration or in the file of a registration are not evidence on behalf of the applicant or registrant unless identified and introduced in evidence as exhibits during the period for the taking of testimony. So what they're saying is, yep, if you look online, you can see your application, you can see a file with a specimen when you showed that screenshot from your website. That's not evidence. It could become evidence if when you responded, you said, according to this Exhibit H or Exhibit whatever, which is the specimen. When I filed the application, we showed the specimen that was used, and I hereby confirm that this demonstrates use as of this particular date. None of that was done. All you had was just specimen, and you're not supposed to just rely on USPTO digging their records and say, oh yeah, she had this specimen, I remember. Let's make the decision in her favor. That's not how it works. Although the file is of record under trademark rule whatever, as dictated by trademark rule the other one, the statements and documents appearing therein may not be relied upon as evidence to establish facts. Respondent's registration is of course afforded protection under Section 7B of the Trademark Act by presumption of validity and ownership. However, once a petitioner sufficiently rebuts that presumption, a respondent must introduce such testimony and evidence sufficient to rebut petitioner's prima facie case. Here, petitioner has established its prima facie case, and it was incumbent on respondent to identify and introduce such evidence, including its specimens of use under testimony, in order to support her various assumptions. So a bunch of things here. First, they say, yep, when you register a trademark, it gives you the presumption of validity and ownership. But all it is a presumption. It's a presumption that can be rebutted. And when somebody challenges your mark, you can't say, well, I got the trademark, bye-bye. That's the whole point of them trying to challenge your mark. So when they show what's called prima facie case, which means on the face value, right? Basically what it means is that if they were to prove everything they say, do they have a case? And so they say, yep, if petitioner were to prove everything they claimed, they would have a pretty good case that your trademark needs to be canceled. And so when they have established that prima facie case and you don't respond, well, your presumption goes away, because now the burden shifts back to you to prove that the trademark is valid, and then you own it. In addition, respondents' assertions regarding what constitutes bona fide use in the ordinary course of trade in the entertainment industry are similarly unsupported by any evidence. No evidence, no win. Very good lesson. In view of the above, petitioner has satisfied its burden to establish the claim of non-use, and it stands unrebutted. So the petition to cancel registration is granted on the ground of non-use. The registration will be canceled in due course. So there you go. There you go. I don't know if Jesus would have done this, but what we can see is two things. One, you got to have evidence of active use of your mark after it registers. Without it, there's the risk that somebody else will come in and try to grab that from you. And the second lesson is that if somebody's trying to challenge your mark, stop playing the lawyer. Get somebody to take care of this. And by the way, if this result is an outcome of Kimberly actually getting legal advice, getting representation, and her lawyers didn't take care of that, that's a great opportunity for a malpractice case, because that is criminal. To not produce any evidence in the case of cancellation proceedings is just beyond words. So let's assume the best, that she was just trying to save money, she was trying to play lawyer, and she was just assuming that if she can, write something in the response, that things would just figure themselves out. Well, they haven't. Now, I hope you found this lesson useful. I hope you don't ever have to go through something like that, but I hope you learn a thing or two. And if you did and you haven't yet, subscribe now, get notified whenever the next video goes live, which is tomorrow. We post these videos every single day. There's always something new. There's always a new screw up, or there's always some question that you may ask me about branding or trademarks or entrepreneurship or stuff like that. There's always something. So subscribe now, get notified whenever the next one goes live, and I'll see you in the next video.